just a reminder that William Bell and Catherine Bell not only gave 110 acres in Bell Park, but they also gave John Island the monies which made the Salvation Army Hostel downtown, monies towards Memorial Hospital. They were incredibly generous, and they've really defined our city in a motherhood and apple pie kind of way. And this presentation will cover the history relevant to Bell Park and the Covenant. I want to just talk about the zoning bylaws and how they're broken, and about the proposed site plan relative to the official city plan and how they are at odds. Obviously, I'm an opponent of this plan, and I just wanted to mention the specific wording of the covenant, which is for the purposes of a public park and recreation ground only, and it's forever. And Mayor Wong did extend this covenant to all concessions of Bell Park and Lily Creek in 1991. That was read 3 times in this chamber. It's bylaw 91-189. And it says exactly as above, for the purposes of a public park and recreation ground only and forever. Now, it's interesting when you look at the Stafford property, it's 2.63 acres, and that between 1944 and 1973, they acquired an additional 1.9 acres of Bell Park land in concessions 2 and 3 in exchange for 0.13 acre roadway allowance and $1 per indenture. I have some of these original indentures, and if it's acceptable, I can present them to council subsequent to this meeting. The original 1944 indenture was a 0.37 acre roadway allowance, a $1 indenture from the Bell Park Road to the lake. And then that was subsequently traded the next year, and I have the minutes from a meeting of the Parks Commission at the City of Sudbury. Mrs. Catherine Bell called the secretary on her telephone on September 11th, 1945, protesting selling any part of the park, stating that the park roadway was a beauty spot, as it was. However, Commissioner Beaton noted that, furthermore, when we had, through council, arranged to transfer 1.57 acres to the Sisters of St. Joseph in exchange for the $50 right-of-way, which only contains 0.37 acres. And these trades and exchanges were finished with an indenture in 1973, where Park Roadway was further exchanged. Traditional Bell Park Covenant land was traded for parkland which already existed. So it's as if I were to buy your car for $1, and then for another $1 I would trade your car back for your house. So you're left with your original car and $2. Now the reason that the generosity was extended in such a fashion, it was a public hospital, not a private for-profit condominium building housing 100 units. It was for the public use of all the citizens to attend this hospital and take their medical problems there for healing. So anyway, here's a map with the final property outline, and you can see about 55% in green is F. Martin Stafford's house, which was a red house. And then the rest of it, the orange stuff, is Bell Park land given by William J. Bell. All right, if you look at this map, and you can see that it's concession 2, that corner down there, that's concession 2, that's original Bell Park Covenant land. That's where the monolithic 7-story parking garage is going to sit. And I don't think that's for the purposes of a public park or recreation ground. That defies the Bell Covenant. All right, here's a Google Earth map. There's parkland, there's Stafford property. You can see that the line for the dividing Martin Stafford's house and lands and the park goes through approximately the front door of the hospital, and the entire B wing of the hospital is built on parkland. Now, the interesting thing about the parking garage is it extends into that bottom triangle right up to the very edge. It is not the half-story above finished grade that the boiler house is. It is 4 stories, so it is much higher than the existing structure at that site. And as well, you can look at the Mason building. Whoops, pardon me, I'll just get my pointer. You can, I kind of have a familiarity because I worked here. You can look at the Mason building. It's right there. There's a big offset with a couple of trees between it and the park. That building is going to be much bigger, and it's going to extend nearly to the back of this property. So it's quite a lot different. Okay, when you look at the landscaped open spaces presented on the diagram, they extend beyond the property borders of the panoramic property considerably. So in fact, the landscaping inside of those property lines is probably only about 50%, or about half requirement. The parking garage abuts on the property line, right up to the very edge with no 10-meter offset. That's against city bylaws. The new condo building rear wall is only 3.5 meters from the back property line. Another break in the bylaws. I could go on for a long time because the problem is we're turning an institutional building into a private dwelling space. So there are institutional building rules, and there are residential R4 building rules, which are quite different. So we're trying to turn a pumpkin into a Cadillac, and it's just not working. Okay, here's a diagram just to point things out. These green spaces are landscaped areas. It's about 1/7. It needs to be nearly 1/3. I don't know how landscaping on city grounds counts as landscaping on property grounds, but apparently it seems to here. I just want you to look at this. This is 7 stories high. This is going to block the view from Bowling Street and Paris Street of the lake. It obstructs corridor views. This, I don't know. I used to go to the Mason building regularly when I worked in St. Joe's Hospital, and this is not the same thing. This is a lot bigger. It's a lot closer to the boundary, to the park boundary. By the way, this is hardscaping. This is not landscaping. I've thrown it in there just to be generous. Okay, I don't want to bore you with a lot of traffic talk, but I do want to go to this point at the bottom. Constant traffic will create a stressor in a space that should otherwise be calm and pleasant. Let me read you some official meetings, official lines from a meeting in 1945. This is a meeting where Catherine Bell objected to changing the Bell Park Road or selling any part of this land. And I'll have you know, she was old then. She was in her 80s, and poor William Joseph, he had passed away. Okay, in 1945, he passed away. Superintendent Butchert said it would be a crime to disturb the present ravine, as it was a natural beauty spot, and with very little expense could be made even more scenic with judicious planting. This is the most beautiful section of the park. There is a spring at this point where a drinking fountain could be installed. Yet this spring still exists, surprisingly, squashed between this neglected park road and a big gravel pit. It's still there, and it still could be brought back to life. Commissioner Waller stated that to divert the road, as suggested, will make the park unsightly. Commissioner Beeden stated he was not in favor of straightening the one-way road as it was a beauty spot.
Doctor, you've extended your 5-minute date. Could I give you 2 minutes, please, to wrap up?
Absolutely. Absolutely. Thank you for your generosity. Okay, here's section 14.5. New land uses or design features that would detract from the enhancement of major focal point areas within the city, such as Science North, the Big Nickel, and Bell Park. We're clearly breaking this with this big project because we're expanding the existing structure. All right, so in summary, we're violating the Bell Park Covenant. We are, and to say otherwise is not true. Mayor Wong has brought this covenant back in bylaw 91-189, we're breaking that. There's lack of open space. We're not obeying the aesthetic characteristics. And I want to remind you, a park is a park. It's not a condo, a private space, a conference center. We owe it to the citizens to bring this park back to life. And there's a very important, one more sentence I want to read out, and it's from our own city Bible. With your, in all due respect, as an alternative to requiring the conveyance for redevelopment for residential purposes, the city may require that land be conveyed to the municipality for park or other recreational purposes at the rate of 1 hectare for each 300 units. For this particular site, that could mean the conveyance back to the city of 1.56 acres of our own historic parkland. Now, I put that letter in Jamie Canapini, the lawyer's, the city solicitor's desk. I asked this guy, I said, why can't we do that? He said, I cannot because I would be violating the confidentiality of my client. I said, who is your client? Who? Is it? I was confused. He said, my client is the city of Greater Sudbury. Well, as a citizen of Sudbury, as a father of 5 children in this town, I find that this project defies and violates our history, our bylaws, our official plan, and I think we need to look at the DNA of this project because it is not good for our city and for our future residents.
Okay, thank you very much, Doctor. Any questions of the doctor at this point? Okay, sorry, thank you.
I have a question for you. Nan, Tonya, I would like you to join me and take some of my time just to clarify some of the things I'm saying.
Okay, could we please move forward?
Is that okay?
I didn't hear you, ma'am.
I would like Evan Roberts to share my time, seeing that he can clarify some of my presentation.
Well, we're trying to work within that 5 minutes, and we're not going to keep extending and extending. So go ahead and say what you have to say. If we have anything that the doctor can help you with, then we'll look at it.
And with all due respect, we've been patiently sitting here for 2 hours.
Name and address, please, ma'am, before we start.
Listening to others, so I'm going to take my time. Thank you. This letter is to object the rezoning of the former St. Joseph Hospital site and to any part of the land areas that the city gave but should have never given to the Sisters of St. Joseph of Sault Ste. Marie, as these lands were protected by the Bell family covenant. The Ramsey lands that were given by Bell family back in 1926 under the Bell covenant covered up, I had 110 acres, which I stand to be corrected. Having terms and restrictions to ensure that the land donated and entrusted to the city would be used only for the purpose of park land for the residents of Sudbury. When an area of the land within the park acreage was given to the Sisters of St. Joseph to construct a hospital, my question is why? As it was park land, not a hospital zone, for what was said to be for the greater good of the residents. Well, through a loophole, what I perceived to be a loophole, that was the end of the Bell restriction covenant. Since then, the covenant must legally be renewed within a certain time period. So I've been informed. City staff at the time of registry knew and should have made provisions honoring the intent of the Bell family, that the Bell covenant would automatically continue to be renewed for the legal timeline allowed. When the powers to be ignore the Bell covenant and sold the land to the Sisters of St. Joseph, there should have been a provision at that very least that when the land stopped being a hospital, that land would revert back to the city and the people of this Sudbury for the dollar. These lands should never have been permitted to be sold to either a second or third party for profit and private profit. The sisters, being paid to run the services at the hospital, had their original investment returned and also yielded a high profit. The extra profit of approximately $1.5 million for the sale of St. Joseph Hospital to the developer from St. Catharines by the sisters should not have happened. The hospital and all of its lands of the area at the time should have and currently zoned for parkland and institutional. For me, it should have never been institutional. It was given as parkland and needed to remain. All of the land and the buildings should require a rezoning permit for residential use. The application of zoning Part 2 and Part 4